Welcome back to one more session. Today in this session, I am going to explain about Ijma under the sources of Muslim law. Ijma is the third most important sources of Muslim law. The first two important sources of law, that is Quran and Sunnah, were not comprehensive enough to deal with all situations that arose as the time advanced. During this period, several scholar jurists who were well versed with the area of law gave their opinions on a question of law. Ijma is the consensus of opinion of various and assorted jurists on a question of law in the particular age. Ijma as a source of Muslim law is also established in Quran and Hadith. According to Quran, O ye who believe, obey God and obey the Prophet and those of you who are in authority. And if ye have a dispute concerning any matter, referred to God and the Prophet. It was given under Quran in the verses 4, 5, 415, 459. 4 verses 59. There can be no consent on error or misguided behavior amongst my people. For Ijma to be valid, it is necessary that it should not be contrary to what is laid down in Quran and Hadith. It is not the requirement that once the Ijma is determined, it remains once for all. A subsequent and later Ijma may be overrule the previous Ijma. Ijma can be divided into three types. Ijma of the companions of the Prophet, Ijma of jurists, Ijma of people. Ijma of the companions of the Prophet. These are universally accepted and cannot be repelled. Abdul Rahim in Muhammad jurisprudence says, great weight will be attached to the Ijma of the companions of the Prophet, in as much as the companions were appointed with the viewpoint of Prophet and remaining close to the Prophet, they had almost adopted the same way by reasoning as the Prophet. However, due weight could only be attached to such Ijma of the companions which was well known in their lifetime and has been held thereafter by reliable men. As already stated that as the time progressed, new situations emerged where Quran and Sunnah were not sufficient enough to cater to the needs of the people and give any sort of guidance to the people. It was during this period that erudite scholars of Muslim law gave their opinions. Amongst them, the topmost were the four Imams of the Sunni school, whose position as companions of the prophets were well recognized. This is about Ijma of companions of Prophet. Next, coming to Ijma of jurists. Though they are recognized, however, there are various and divergent views with regard to the exact number of jurists required to form Ijma. What kind of decision will be binding, whether jurists have to give reason for the decision, etc. The last one is Ijma of people. This kind of Ijma, although not given that much importance, but on issues relating to fasting, pilgrimage, prayers, etc. It was the Ijma of the people that was given much weightage. As to the authority and validity of the Ijma, there are difference of opinions amongst the Shia and Sunni schools. While Sunni maintain Ijma to be a valid sources of law, Shias do not keep an eye to eye with such opinions. According to them, Sharia cannot be authoritatively and convincingly determine the conscience of opinion amongst the various jurists. Finally, what I want to say that Ijma as a source of Muslim law plays a very pivotal role. In the words of Daniel Latifi, according to him, the principle of Ijma was given an overriding authority and was made the final and conclusive argument on everything. By the early schools of Muslim law, Ijma regarded as authoritative not only for discrediting the right at present and in the future, but also for establishing the past. It was Ijma that determined what the Sunnah of the Prophet had been and indeed what was the right interpretation of Quran. The final conclusion or the final analysis, both the Quran and the Sunnah were authenticated by Ijma. This is a brief with respect to Ijma as a sources of Muslim law. Thank you.